end of March 2025. So some of these, I'm going to go through a quick kind of PowerPoint that I've put together that we've had to present a few times. I'm going to cut out the stuff that's not relevant for you guys. And then I'm going to open up the questions, and I'm just warning you in advance. I mean, some of the questions, the answer is going to be, I don't know, because it's only been enforced for about 30 days here. So we're all kind of figuring it out as we go. But I'll give you guys kind of the general overview, and then how you can kind of use that for your clients and things like that. So again, that's me. Let me go through the slides here. So for anyone who's just sitting there being like, I don't even know what wholesaling is. So wholesaling is just putting a property under contract with the seller and then selling the equitable interest in that contract to a third party. And it's basically like being a middleman. So I'm going to use Mary for examples here, since I know Mary. So basically an example would be Mary wants to sell her house, and the house is at 123 Main Street. I go to Mary and I say, I will buy your house for $100,000. And she says, great. We sign an agreement for that. I then take that contract and I go to Christina and I say, Christina, I will sell you this contract to buy this house. You have to give me $105,000. And Christina says, great, it's still a good deal. So then at the closing, Christina brings $105,000 to the title company. They give the $5,000, what I call the spread, or the difference between the contracts, to me as my fee. And then the remainder would go to Mary. That's basically what wholesaling is in a nutshell. So I never actually take title to the property. I'm not on the deed. I'm not on the closing docs. I'm just on the settlement statement, as sometimes you'll see it as assignment fee, sometimes finder's fee, etc., things like that. There are exceptions to that, but that's kind of what 95% of the wholesale contracts look like. And again, we got the example here. So seller is the owner of the property. The wholesaler signs an agreement with the seller for $100,000. In this example, the wholesaler then sells it to the buyer for $120,000. The wholesaler keeps the 20, the buyer brings 120, and seller gets 100. So Act 52, which is the actual legislation that came into effect, falls under RELRA, the Real Estate Licensing and Registration Act, which everybody in here who has a real estate salesperson license, you're all compliant with RELRA. It's now going to define wholesaling as a real estate activity. So if you want to wholesale, you now have to get the real estate salesperson license, which is exactly what all of you all have. And you have to hang your license with a broker. It's the exact same, the test, the hours, the things that you guys have to go through, the CLEs. Now, if a wholesaler wants to be licensed, they have to do the exact same process. The basic the background to that really is, the wholesalers would tell you they're not providing any real estate advice. They shouldn't be subject to this, but I think we can all agree, obviously helping or, assisting buyers and sellers going into real estate transactions, there's really no reason they shouldn't have the bare minimum education and license that you guys have to go through. Just allowing them to just be outside the system wasn't really benefiting anybody. But the big key here with Act 52, there's two components. Again, one is if you're going to wholesale, you have to get licensed as a salesperson, hang your license with a brokerage. The second part is when you're doing a wholesale contract, there's a few requirements that have to be in every single agreement from now on. And a similar example for you guys would be when the nonsense last spring with all the craziness with the commissions are in the par form, and they've put it in there that, buyer will put X amount or seller will offer buyer's agent X amount. And now the MLS can't have buyer agent commission and all that nonsense. Same exact thing with this, where there's now new requirements that have to go into these agreements. Again, have to have the license, they got to do the CEs, etc. So what in the past, wholesalers would put a property under contract. Generally, they would not tell the buyers they were wholesaling. And then when the sellers and buyers showed up to closing, the parties had no idea who each other were. And there was no requirement to disclose that you were wholesaling. So a lot of times there was just, frankly, some shady or kind of some unethical activities, whatever you want to call it. But people would have no idea. And I run a title company in addition to my law firm. We would see wholesale contracts go under sale. It would go under wholesale at 40 or 50,000, and then the end buyer would be 75, 85,000, and the wholesalers were bringing $30,000-$40,000 spreads on these deals. And I think there was a lot of complaints to the Attorney General's office for the Consumer Bureau. I know for a fact, there was a lot of complaints to the Real Estate Commission. And that's kind of how this whole thing came about. So I'll try to keep some of this. Again, these are the requirements. You guys are not attorneys. You don't need to know all these, but just so you have a general idea, these are the 4 new requirements that have to be in every wholesaling agreement for it to be enforceable. First one is you have to tell somebody, hey, I'm going to wholesale this deal. I have the right to actually wholesale this. I might not be your end buyer. That's number 1. Number 2 says, if you're going to put a wholesale property under contract, you have to put something in there that says you have the right to get an appraisal on this property. Because again, they were trying to stop wholesalers from under marketing and undersigning these properties. The third one, which is a big one, this is causing a lot of the confusion. When you put a property under contract, the seller has 30 days to back out under that agreement for any reason or no reason. It can be anything they feel like. It doesn't matter whether you put hand money down. It doesn't matter whether you've already made improvements on the property. You could have already moved in. It doesn't matter. They have 30 days. Basically, they can walk away from the deal for any reason whatsoever. That one, and I call it the you can cancel for 30 days rules. There's no way around this. You can't offer an incentive to get around it. You can't put more money down. The only thing that can get you around this is if you close before the end of the 30 days. It's 30 days or closing. And then the last one is if the seller terminates the deal, you have to refund them any payments. So if they made any payments, like let's say they've paid taxes because they wanted to close it or something, they gave you money, anything. Can't offer like prize money to them, anything like that. It all has to be refunded no matter what. So again, some of these, I know you guys are just doing the agent side, but just so you have an idea, there are new requirements that have to be in every agreement. If these requirements are not in the agreement, it is not enforceable. So again, in English here, you have to tell the seller you're wholesaling it. You have to give them a right to an appraisal. The sellers can cancel it for any reason or no reason for 30 days, and you have to notify them that they will get their money back if they cancel. So I'm going to skip some of these because these are more about some examples of those. Okay. So the consequences of wholesaling without a license. So what's going to actually happen is the question, right? Like we keep seeing these guys wholesale and they're not following the rules. What's going to happen now? First step is I think there's going to be an increase in complaints at the Real Estate Commission. Sometimes the Real Estate Commission is on the ball in terms of enforcement, and sometimes they're not. I'm sure you guys see that even more than I do, but that's going to be the first thing. The second thing is this statute allows criminal charges to be brought. Now, I haven't seen any criminal charges brought yet. Obviously, it's only been in enforcement for about 30 days, not quite even. So, we'll see on that one. I do think that will happen as time goes on. I just think it's going to take some time. But the big one is this third one. It's an unenforceable contract. So the fee cannot, the wholesaler cannot collect the fee on it. And when we say the word unenforceable contract, it basically means it's an illegal contract. And the example that I always use is, let's say that I want to hire a hitman, right? I want to take somebody out. So I hire a hitman and say, you can, go knock this person off for me. And I pay him $50,000. Well, they don't end up following through and the person doesn't get killed. I can't sue them in court and say, hey, I hired you as a hitman and you didn't perform. You need to give me the money back. It's an illegal contract. It's not allowed. Another example would be like if I'm going to buy drug shipments, somebody like I'm going to purchase this from you and you don't perform, my drugs never arrive. I want to sue you for not performing. Okay. It's not allowed. It's an illegal contract. So again, not enforceable. So the big thing here though, for your perspective is these wholesalers, when they're going to start getting cut out of these agreements, and we'll talk about that, they have no legal recourse whatsoever. And I think it's a big thing for you guys is explaining to your clients as these go is they have no recourse against the client. The client doesn't need to be nervous about like, well, what if they sue me for their fee or something? Absolutely not. It's an illegal contract. They didn't follow the rules. They're not allowed to do that. So some other things here, just kind of some like to kind of wrap some of this stuff, just going through like some things you guys see on a daily basis, like how are just seller disclosures going to work under Railroad or the wholesaler? So let's say you represent a buyer and you see a property on the MLS for 123 Main Street, and it's advertised as, I'm wholesaling this, I have an equitable interest. Well, how's that disclosure going to work? Because that wholesaler's never resided in the property, most likely. They've probably not even done the bare minimum homework that's required to wholesale. Most of these guys don't reside in the state of Pennsylvania. They send mass mailer flyers out and say, I'll buy your house for 40 grand, and then they just try to sell it. So nothing in this statute exempts a wholesaler from executing a disclosure statement. So in theory, the wholesaler still has to bring a disclosure statement. How are they going to know? As you can see in the third bullet point, how does a wholesaler know what is or isn't wrong with the property? That's a great question, and that's one of the big issues that I think is going to be the first domino to fall in terms of lawsuits here. Is, again, these disclosures from these wholesalers, they're just turning them in blank, not even signed, not anything. And as you guys know, that's a big no-no. Obviously, you can't do that. And I think that's one of the first ones is going to fall. Somebody's going to buy something relying on that disclosure, not fully understanding it was a wholesale deal. They're going to file suit, and somebody's going to get slammed for it. But that's something to kind of think about. If you have a buyer purchasing one of these, you really want to be careful with that disclosure, because who knows who filled it out. You really want to check, like, who's the name on the bottom of the disclosure? Is it the wholesaler or is it the actual seller? What kind of information's in there? Is it saying, resided in property for 20 years and the roof's never leaked? Or is it just saying unknown or no information, etc.? Because in my opinion, a wholesaler filled out seller disclosure statement's basically worth nothing. Another change that we're seeing, since wholesaling is licensed activity, a wholesaler can actually accept a referral fee now, because again, it's just like anything else. So if you had, if you referred, let's say your friend lives in Philadelphia and wants to sell their house and you guys don't want to handle it because it's too far over the state, maybe you call up the local Realty One group out in Philly and say, hey, we're going to, I have a house, I'd like to take a referral fee on it, etc. The same exact thing can happen with wholesaling now. And what I've noticed so far is I've seen agents taking referral fees on kind of full flip or full gut homes that are really just not worth that much, frankly. I just closed one earlier this week where the agent had a friend who owned a house. They were going to list it on the MLS for $18,000. It was basically destroyed. So the agent, instead of doing that, they sent it as a referral to a licensed wholesaler. The wholesaler went out and found a buyer. It closed at $25,000. So there was a $7,000 spread. The wholesaler gave half of that fee to the agent. So the agent netted $3,500 in fees and ran it through their brokerage, just like any other referral fee, of course. And the agent ran it under their brokerage, got $3,500 for the wholesale. And they split it. And it was, the agent said to me afterwards, like, my commission on this would have been $2,500. And I would have put time and money into photos and listings and meeting people and blah, blah, blah. And this just frankly wasn't worth my time. I'm like, yeah, it actually works on some of these smaller deals. So it's an interesting change that I've been seeing, at least, is that's the first one. Again, an agent who signed a very, very small deal that really wasn't, they're not going to get a loan on this property, right? It was destroyed. So they found an investor and they just took a cut from it. And that picture is from when Matt and I started our firm 11 years ago. So I do not look like I'm 15 anymore either, but which was a joke for the bar that we had to put it on. But anyways, I feel like it's probably a good time just opening up the questions. Does anyone have, I know that was a lot of info I threw at you, but any questions here?
Mary has a question.
Okay. All right, Mary, go ahead.
Okay, so because they have to be licensed now, obviously then we have the right to ask them for a copy of their license.
Correct. Yep, exactly.
Okay, and then
and you can look them up on PALS, any other registration, licensing. Exactly. They will have to be up there hanging their license with the brokers, just like everybody else in Pennsylvania.
and it has to be in Pennsylvania because I deal with a company that is out of Georgia.
Correct. So that's one of the big, that's where I think the hammer is going to come down is you have to be licensed in PA. can't be licensed in another state, and there's not automatic reciprocity. So if you are licensed in another state, that's okay, but you still have to get your license in Pennsylvania. No way around that. Can't work. And there's no like reciprocity. There's no, oh, well, we have a brokerage in PA and I'm just, kind of handling this for them. Like, no, they have to follow the exact same rules that you guys follow.
Okay. And then my last question. So if we have, if we're called to list one of these properties, which that I've sold one recently representing the wholesaler basically, and the client has already signed their contract with the wholesaler company, and I'm coming in to list it, obviously to bring more money to the table. Are we allowed to request a copy of the contract and then educate the client on the fact that it's actually an invalid contract with the wholesaler, even though I was hired by the wholesaler? And then in regards to having the listing ultimately back again, but with the actual client that is selling the house. I mean, is there any legal repercussions there?
So that's kind of the one of the big questions that I don't know the answer to yet. I would say as a baseline, you guys have, I feel for you guys as the agents, because you really are in a tight spot where you can't give legal advice, but you're working on legal transactions all day. So where does that line like actually stop? In my opinion, I think you're fine to tell the client, hey, this is the wholesale agreement. Here's the things they have to do, the right to appraisal, the right to tell you it's wholesale, et cetera. If they didn't follow them, it's like, look, it's not an enforceable agreement. It's your decision, Mr. and Mrs. Client, how you want to handle that, of course, but this is not enforceable, because I think at the end of the day, you guys have a duty to your client. So even on those ones where, you rep the wholesaler, you still have the seller sign some type of agreement with you guys so you can put it on the MLS and handle things like that. But at the end of the day, the duty you have is to your client, because it's your name that's going to be on this. So I think it's fine. I think there's nothing wrong with it. There's certainly no legal repercussions you would have. Like the wholesaler would never be able to come to you and somehow file suit someday. I mean, they're not in compliance. So there's absolutely nothing they can do. It's more, to me, it's about, what do you want to deal with in terms of, the fight that could come someday from that? That's really, the question. And if the wholesaler says to the client, hey, I don't know, your agent's wrong about this, whatever, and tries to kind of, start a fight or whatever, that's really up to you how you want to handle it. That's more a business question. But
So I have a question. You had mentioned that, if a wholesaler is working illegally without a license, that a claim can be filed, or, a notice can be filed to the real estate commission. With this change, have they changed the policing power of the real estate commission? Because the real estate commission can only police licensed individuals and not unlicensed individuals. So isn't that counterintuitive?
You are 100% right. And that's something we've been saying since the beginning. And we basically been told, we'll figure it out. And right now, I mean, they've told us report it to the real estate commission. I haven't seen it yet, but I have a feeling they're going to say exactly what you said, which is this is unlicensed activity. We don't have jurisdiction to actually enforce this.
Oh, and we know that they don't. We know that they don't, because that's been part of the ongoing problem with some of the shady wholesalers, is that there's no police power to stop them unless an individual person who has liquidated damages sues them in a civil setting.
Yep. And yeah, as you probably know too, I mean, good luck. You sue them for damages, good luck. Most of these guys don't have anything. Half these guys, we dealt with one, I could tell the story. We had one blow up on Monday, and they're out of Singapore. I mean, good luck. Like, I'm never even going to find these. The wholesaling group is out of Singapore. I mean,
they're shelf companies. They own nothing.
Exactly.
They're LLCs owned by other LLCs owned by other LLCs that literally own nothing.
Exactly. I mean, the client on that one wanted us to, I could tell a story, but we basically told him, like, look, the money you spend on me is just, you might as well light it on fire. I mean, I'm not going to be able to accomplish what you want me to, so don't waste your time and money on me for it. But
I have just one more. I have an actual situation to where I'm in another transaction representing the wholesaler, and I was offered on a property $100,000 cash, no contingencies, and they decided not to take the offer. But I know for an actual fact that if I had called the seller of the house, she 100% would have taken the offer. But because the wholesaler company has this limited POA to represent her, I have to run all of the offers that come to the table through them, and then they call her. So what would be her rights in that aspect?
So that one's a little complicated. It would depend what's in that limited POA. They may have given her the rights, or she may have given them, I should say, the rights to negotiate on her behalf. But at the end of the day, if they are not a licensed agent within Pennsylvania to perform wholesale, she could just basically tell them pound sand. Like, I'm taking 100 and I'm not giving you anything if I don't want to, because they don't have any right to it.
Well, I think that's a big question for most agents is where does the fiduciary responsibility lie and where does our confidentiality lie with our clients? Because, the law is very clear that our fiduciary responsibility is to the client in which we're under contract with, and confidentiality runs the same. So if the, quote unquote, whether, this unlicensed wholesaler is the one to, for example, hire Mary and goes under contract, in essence, becoming her client, at what point do we draw the line? Because they're not the legal owners of the property, and the seller should be the one who is the client, but the contract reads that we basically can't break confidentiality with the wholesaler, and that our fiduciary responsibility needs to trump over the seller to the wholesaler, even if it's not in the community's best interest.
I know. And that's a great question. And the answer is right now, we don't have an answer. Part of what I've said this to Mary before, but like part of what I'm looking for personally on my law firm side, we're looking for a deal like that we could basically file suit on to set some type of precedent that you guys are in an impossible situation, right? I mean, really, you're just in an impossible situation because this POA says you can't discuss this with the actual seller, but they don't have any equitable interest of the property. They're performing unlicensed activity. If you go around them and talk directly to the seller and contract with them, what are their damages? I mean, it's none. I don't see how they could have any damages because they're not licensed. But that doesn't mean if you go around, it doesn't mean maybe they do try and file suit on you and make your life difficult.
But here's the problem is that they're working in an unlicensed, illegal, situation. We're doing, what we can as a licensed person, but that wholesaler has the power to put in a complaint with the real estate commission, who does police us, but can't police them.
Yep. I know you have to play by the rules and they don't. I know it's why we're trying actively. My partner and I are looking for one to file something to set the precedent that going around that POA is not a breach of your duty. Your duty is to the end seller, not them. But right now, you're exactly right. I know that answer is not clear at this time.
Real estate commission, you're not innocent until proven guilty. You are guilty until proven innocent.
Even still guilty sometimes.
That's just the way it is. Because they have their own, they have their own inner workings. They play by their own rules.
Yeah, I know.
So
I mean, I don't blame the agents, especially. I don't blame you guys for being on the extreme side of caution, because let's say you go around them and you get it sold and they file a complaint on you. Is it really worth the headache for all of that and all the nonsense? And what if the real estate commission comes to the wrong outcome because they don't know either, and then you're dealing with this, and it's 100%. You guys are kind of in a holding pattern almost, which is why we're trying to find one on the law side to basically set the case, to set the precedent on this, so that if we could get some type of case saying you don't have to honor these POAs, they're not a violation of your duty. Your duty's to the seller, not to these guys who are doing unlicensed activity. I think it would clear this up entirely. But until it's been codified with some type of case law, it's kind of up in the air right now. And you're exactly right.
That becomes layered and very complicated, because when we're talking about POAs for sellers, with wholesalers, that's not the only time that we deal with POAs. A lot of times we deal with POAs for, mental incapacity issues or medical issues or, whatever the case. So then that opens up a can of worms of what POAs are enforceable and what are not.
Yeah, I know. I mean, like I'm working on one with Mark right now. That's a medical and POA for a closing. And Like that one, obviously, it was drafted by council. It's recorded in Beaver County. It's obviously valid. It's clearly valid. We've met all the parties, but I know. I mean, I personally don't think these are going to be, those POAs will be enforceable at the wholesalers, but that's my opinion. And I fully will admit it's easy for me to say, because if they file suit on me, great. I mean, this is what we do all the time. I'm not worried about it. Way different for you guys, obviously.
Mm-hmm.
Yeah.
Well, I have a couple other questions, but please, you guys who are on the line, April, I know you had a couple questions a couple weeks ago. Anybody, please jump in. Anybody? You guys are quiet today.
I got
Go ahead,
real
Renee.
quick. Oh, go ahead.
Yeah, he was saying about the disclosures, that they have to be filled out and not blank, but if they're selling it as is, aren't you able to not have anything on the disclosure?
That's yeah.
If
So
that
that's
makes sense.
kind of, yeah. So usually, like, we see the safest ones, the as is, or like an estate house, maybe, you know, grandmother passed away in the house, the estate's selling it, grandson or son, whatever, never resided there. The wholesalers use that as is, whereas language, but really it's like, I think when it gets litigated, it's not going to be valid, because you have to at least try to give this an effort, right? I mean, the way they look at this is like, you have to try. If you've never resided there, you have no info, great. But if you're a wholesaler, you would, at least in my opinion, have a duty to disclose what the seller tells you about the property. And the seller's there. How do they have no information about the property whatsoever? I mean, that's like having a seller just sign it and say, I lived here for 25 years. I don't know anything, nothing, and leave it blank. I mean, I'm assuming you guys wouldn't be comfortable having something like that on a disclosure.
Yeah. So my question is, so we're talking about like wholesalers getting their license, and I mean, wholesalers who have their license in essence aren't wholesalers anymore. Wouldn't this just kind of revert back to, you know, real estate agents who specialize in investments, who are doing basically net listings with sellers? And for those of you who don't understand, like, net listings, it just means you show up at the property and the person there says, well, I want $25,000 for my home. And you say, okay, I'll get you $25,000. And anything over and above that is my profit. So if I only get you $25,000, then I make nothing. But if I get you $50,000, I make $25,000, which are not super common because they're so open to litigation in most brokerages. But is that kind of what they're aiming for, is to bring back those net listings with these wholesalers?
Yeah, I think that's basically what it is. I mean, they won't say that, obviously, but that's exactly how it works. They put the wholesale in their agreement. I'm going to buy it for 25, and then they sell it, you know, they ship it out there and see whatever they can get for it. So I know, but technically the statute is amended to call them now wholesalers. I mean, that word's in the statute. It's the Wholesaling Registration Act. So, but you're exactly right. I think they're basically net listings. And I know for a fact, like we've talked to a Remax branch about this, and obviously you guys have your own policies. They have theirs, but they were just like, no wholesaling whatsoever under a brokerage. We're not allowing our agents to do it. It's too much liability. There's going to be a lot of lawsuits coming up, and frankly, it's just not something we want to be associated with. And I think that's what a lot of brokerages are going to do, frankly.
Mm-hmm.
Yeah. I mean, just a quick story. We had, like, so how this will play out in real, kind of in practical terms. I had a closing on Monday this week. I'm not the attorney for anybody, so I don't have a confidentiality, but I won't use any names. We had a closing on Monday. The seller had it under contract with a wholesaler at 50. The wholesaler shipped it out to an end buyer at 59,000. Did not disclose that it was wholesale, nothing. And they've had this under contract since like September. They basically just sat on it for like 6 months, waited until they got a buyer, and it got to that point. So we get to like maybe 3 days before closing, and the seller has a mortgage on the property, and the mortgage payoff was about $1,000 higher than she thought it was going to be. So she called the wholesaler and said, I'd like for you to cover that 1,000 because I signed this with you, 8 months ago, and I thought this was going to be done by then. Wholesaler says no. So we show up to closing, and she thought that the wholesaler was the buyer. They come to the closing table. It is not the buyer. she is very upset, and she basically just, once they figure out what's going on, she says to the buyer who's sitting there, like, they figure out it's $9,000. She goes, why don't you just keep 4,500? I'll keep 4,500 off of this. We'll just call it the original purchase price. Don't worry about it. Let's just cut them out of the deal. And they all signed, and we sent it to the wholesaler, and they asked us, like, where's our payoff? And I told them, like, it's not coming. Sorry. Like, these guys are out of the state of, they're out of the country of Israel. They're not in America, and they got cut out of the deal, and they freaked out. And I basically told them, like, pound sand, like, here's my office address. If you want to sue me, go for it. Like, I'm happy to defend this. You're not a licensed wholesaler. I had nothing to do with it. I mean, they all figured it out. The wholesaler just cut out of the deal right at the closing table. And I think that's how it's going to work until they get licensed. I mean, I know enforcement, it's great in theory, and you're exactly right, Christine. I mean, I deal with the commission too. Not the bad talk them, but it is what it is. But
It's a broken system.
They're doing no work and making a lot of money. Austin, we saw this, you and I saw this. And sometimes the seller has no idea that they've even been wholesaled until a licensed agent shows up to list the house.
Yep.
Happens a lot.
It's actually pretty crazy.
Yeah, I know.
So I have another question for you, just at a brokerage level. If somebody like Mary, and like I said, I know I'm picking on Mary just because Mary put all this together. So I'm picking on her, and she doesn't mind. But there are other agents on the call that have done, these wholesale listings. I've done them myself, but given the new rules around wholesaling, do you think it would be a good idea for us to have some type of disclosure that the seller would receive, that an attorney can write up that says, okay, I'm representing the wholesaler, and you have, like, you're doing whatever you're doing, but I have to meet with the seller, and the seller has to sign our brokerage disclosure that says on there, these are the new rules. I'm informing you of your rights, and I'm notifying you that you are in a wholesale contract, and that you're signing this without the rest, being fully knowledgeable that I'm selling your home and you have no control over what's going on. And that I can't share confidential information with you, even about your own property and your own situation.
I think that's a great idea. And I think that will immediately launch into the conversation of, like, what am I signing? Like, what is this? Et cetera. Like, that's a great idea. It's, I haven't even, the funny thing is, the other ones we've put this on, nobody's actually brought that up yet. I've thought about that, and then I didn't say anything, but that's a great idea. It's exactly how I would handle it. And I think that will launch the conversation into, do you know what, without bringing it up yourself.
Talk about afterwards, how we can have you write that up.
I was just going to say, come on, Austin, do it for us.
Yeah. I mean, like, in full disclosure, like, I'm the broker of record for a wholesale brokerage we set up in January. It's one other agent with me. And we have, like, obviously all of our contracts are in compliance and everything, but, like, we have the buyer sign with the wholesale saying, like, this is what we have, but you're free to speak with the seller directly if you'd like to for personal information, because we have a signed agreement. So if they tried to cut us out, we would be able to actually enforce that, because we're, licensed, we're running it through a brokerage, et cetera. But no, it's a great idea. That's exactly what I would do for these, especially these out-of-state PA. There should be, I'll say this. If one of my licensed guys says, hey, the buyer agent brought this form and wanted the seller sign it, and we reviewed it, like, yeah, no, it's perfectly valid. Have them sign it. They're just protecting themselves with that.
Mm-hmm. And I think that's the position that we need to take too. Because if somebody makes a complaint to the real estate commission, they're not making it about the wholesaler. They're putting it on us.
Yep.
They're putting it on us because we have the license, we have something to lose, and we have the insurance policy to go after. I mean, that being an attorney, I'm sure, I'm not telling you anything that you don't know. Anybody who holds a professional license is under fire, and the higher you go, the more under fire you become.
Yeah. No, it's all, I don't do personal injury work like the Edgar Schneider and Morgan & Morgan stuff, but it's the insurance and, like how do you collect on these guys? They're out of the country. I mean, good luck. But how could you collect on the Realty One group? Well, that's pretty easy. You're all over the place. You got insurance, et cetera. So,
yep.
Yeah.
Yeah, and it's real easy to hit somebody with that $8,000 lawsuit and hope you'll settle out of court to make it go away.
Yep. And that's exactly like I'm saying, like when Matt, my partner's name is Matt, not Matt Briancesko, but when Matt and I, like, that's why we're trying to kind of get this handled and try and get one of these handled kind of set up, because they can sue us. I don't care. Like, they don't have a claim and we don't want to litigate, but I'm happy to do it if it would make things easier and kind of settle some of these cases. So figure these things out.
So when they're using the term novation, what is that and what does that entail? Because that's a question I've got here at the brokerage a couple of times.
Yeah.
Like, what is this novation and what does that mean?
So a novation is actually basically the same thing as an assignment. Here's the difference. So let's say Mary and I sign a contract, and we sign a contract that I'm going to provide her 100 widgets at a price of $1 a widget. So she's going to pay me $100 and I'm going to produce 100 widgets. In that contract, I may have something that says I have the right to assign my proceeds in this contract to somebody else, to a third party. That's an assignment. So an assignment is just assigning certain portions of a contract. But I still have to perform, meaning I still have to produce these widgets to Mary at 100 of them for $1 a piece. The money's just not going to come to me. I assign those proceeds to a third party. If I novate a contract or the novation, I'm fully stepping out of the contract entirely. So Mary and I sign an agreement. I'm going to, sell her 100 widgets for $100. I then say to her, hey, I'm novating this to Christina. Christina's going to actually be the one to make these widgets, sell them to you, do every single duty on here. A novation is a full assignment, but you can always assign certain portions of an agreement, but not all of it. Whereas a novation is the entire agreement's, for lack of a better word, assigned. Novation is just a full assignment. The key you see that is for transfer tax purposes for Pennsylvania, an assignment is technically transfer tax payable. So if I put a property under contract for 50 with Mary and I assign it to Christina for 100,000, in theory, I'm supposed to pay the transfer tax, which is 2% on the 50, and the transfer tax on the 100. So there'd be extra transfer tax due. The novation eliminates that. If I novate it, there's no double transfer tax. It's just taxed once. It gets kind of complicated. It's called the Bear Brothers case. It's a Pennsylvania Department of Revenue case that lays out when is there double transfer tax and when is there not. So we have a novation agreement every time. My guy would handle it. We do a lot of novations in the investor world. Like if somebody puts them under contract under one of their LLCs, they make a new one, they novate it to their other LLC. That way there's no transfer tax. But don't let them confuse you. Novation, assignment, it is the exact same thing. It's just basically splitting hairs. I mean, an assignment, you can assign portions of contract. A novation is the entire contract is assigned. But the way the wholesalers use it, it makes no difference. And it's not a workaround around the statute either.
How do we know when we're running numbers if it is not going to be double transfer tax or if it's only going to be one set of transfer taxes? Because I've been running it as the seller's paying two sets of transfer taxes because that's what I was told to do so that the numbers don't come up short.
So if it's a license agreement with a valid novation agreement, it's going to be one. I think it's safe to do two. I will say this, and this is more of like a title company question. Pennsylvania has not enforced this assignment double transfer tax religiously. There are some title companies who focus on wholesaling only, and I know for a fact they don't collect double transfer tax. If Department of Revenue ever checks someday, I mean, they're basically screwed. Will they ever check? I don't know. The big thing though is it's never been a licensed activity, so they've never really had an incentive to truly crack down. I haven't gotten anything like on my end. I haven't had them audit any of my files or anything like that, but it wouldn't shock me if they start. Now, if the wholesaler is licensed in PA, it's a valid agreement and it's a novation agreement, it's just going to be one transfer tax still.
So that leads me to another question, because we talk about wholesalers using these novation contracts now to get around double taxation, and they think they're skirting the rules, which you've already said they're not. But if Novation transfers 100% of the contract from one party to another party, doesn't that also transfer their ability to collect assignment fees and commissions from the original party?
You're exactly right. It's funny you say that because I say it to them all the time. Like, do you understand? You gave away your own fee in here. This isn't actually carving out your fee. Now, if you're licensed in PA and you do it as a Novation, you're collecting it as a commission technically because it's coming under your brokerage.
But
so
these people are not.
Exactly. They're not. Exactly. And they're not even licensed salespeople. So you're exactly right. I mean, their form's wrong from the beginning, but they're not even using it properly and they're giving away their own rights under here anyways. Yep.
Okay. Good to know.
Yeah. And then there's this one thing going around. They say like, oh, Novations have been around since 1600s, England common law. Like, don't let them confuse you. It's not true. It's just nonsense. I don't know where they got it, like ChatGPT or something, but yeah, not a way around the law, not enforceable. And if you look in the statute, it literally says in there, Novations are explicitly not enforceable if you're not licensed, that is. So yeah,
Perfect.
no way around it.
All right. Does anybody else on the line have any additional questions? No? All right.
No, I just want to add, like, I didn't end up actually listing the property, but I had someone who had a contract with a seller. And when I came to the house, like, I don't even know that she knew what was going on. She just kind of was like, I thought it was Berkshire Hathaway, and I don't even know if she knew what was going on. And then when I told her what it would list for, she wanted way more. So I think it's great that they give them the right for the appraisal because they think that they can get so much more and they really can't. And who knows what they went under contract for.
That's a really good point. Yep. It's a double. The appraisal stops the wholesalers from taking advantage of them, but exactly. Sometimes, you guys see it more than me. Sometimes they just need a reality check too. The appraisal is a good reality check.
All right. Well, thank you so much for being a guest on our One Chat. We hope to have you back again for other topics other than this whole crazy wholesaling scenario. But for those who would like to get a hold of you after the call, can you give them a telephone number or an email they can reach you at?
Yeah. So geez, you can find us a million different ways. But probably the easiest would be my email, which is aking, AKING at riversidesettlementservices.com. I also have a law firm. I'll send out something you can send out, Christine, if that's all right. I can put our info on there. Mary can attest to this, but I try not, I'm pretty relaxed. I'm pretty laid back. I'm not like most attorneys where it's like, you can call me with stuff. We're not billing you. The clock's not running. That's just not how I do things. So yeah, if you got questions, just give us a call. We're happy to help.
Excellent. Thank you so much. And anybody who wants his contact information, please let me know. I can get that out to you in an email. And if you have any follow-up questions, just shoot those over. We'll put those together for him in case there's anything that we forgot to ask. But thank you again. It was so nice of you to join us. And please follow up with me later on today or this week about getting that disclosure together. I'd like to do that.
Yeah, perfect. I'll send you an email.
All right. Thanks, guys. Have an amazing rest of your day. And if I don't talk to you before, have an amazing holiday.
Thank you. Thanks, Austin. I really appreciate it.
Of course. Thanks, Mary. See you guys.
Yeah.
Thank you. I really appreciate the way you broke everything down. Have a happy Easter.
Yes, you too.